Can we invite you to say a word of prayer for us? I'm sure you'll give thanks for your full fitness this morning.
Let us pray. Righteous and Heavenly Father, we thank you, Lord, for giving us breath to see another day. We thank you, Lord, for taking everyone here safely this morning to discuss the nation's business. Guide our thoughts, guide our thought processes, Lord. In Jesus' name I pray. Amen.
Amen.
Thank you. Any apologies for absence, Miss? And let me welcome the members. We have a quorum starting almost on time because it was built up here for pretty early given another committee follows. All right, we went through the initial part of the report. Remember, Gordon, you think we can proceed to page 22, which is new provisions. I think the matter is circulated, and to then look at the proposed amendments. We're going to read 22 to. If you want to start first and share it with.
Where the 22s
22.
starts.
22 start new provisions.
You want us to just read 22 through to 28? Yeah. All right. Who's going to read? You want? New provisions to be included in Act, power of search and seizure. Your committee notes a proposal from the Office of the DPP for the power of search and seizure to determine whether there should be a default position which required having a search warrant on the basis that it was signed by a JP, and then examine the circumstances which may permit search without a warrant. That sentence could probably be made a little clearer. I don't know, maybe the technical people could help with that. It was suggested that it should be a general power rather than be limited to this act. During the deliberations, your committee was advised of search and seizure provisions with varied approaches in other pieces of legislation. Your committee does not accept the proposal, I don't know what proposal that is, but recommends that the power of search and seizure should be a general investigative power of the police that is addressed as a consequential amendment to the Constabulary Force Act. Your committee further recommends that the new provision in the Constabulary Force Act should specifically indicate that it does not override any provision relating to the power of search and seizure that currently exists in other legislation. So if that first sentence could just be clarified a bit so that we know what recommendation.
It lacks clarity. So the proposal is for the power of search and seizure with warrant as a default position, and then to see under what circumstances would the law permit the police to search and seize without a warrant. That's basically it. Because there is no standard provision in relation to search and seizure.
Right, and so the recommendation is that this will be put on, there'll be like an omnibus provision in the Constabulary Force Act would apply, save and except where other legislation had some specific arrangements in there. All right. New provision, forfeiture of assets upon conviction. Your committee notes proposal from MOCA to add forfeiture of assets upon conviction, as well as the immediate cancellation of licenses or contracts awarded to accused persons by government agencies, probably should be agencies, or entities, as new provisions in the Act. In relation to the cancellation of licenses and contracts, we noted the legal implications thereof, as well as the implications regarding third-party rights or situations where a gang leader has equity, directly or indirectly, in a company that has been awarded contracts. We also discussed the need to address the issue as it relates to gangsters who are responsible for serious crimes in the society and were benefiting from public contracts with allowances for the protection of innocent third parties. We were advised by Attorney General's Chambers of research done where it was found that there were weaknesses and gaps identified in the Public Procurement Act. One such weakness was that after being awarded a government contract, if there was an issue which arose about a major shareholder or director's fitness and propriety, this was not ground to cancel a contract. The Attorney General's Chambers advised that the better approach to address some of these issues in relation to public contracts and public entities would be to amend the Public Procurement Act. The Ministry further suggested an alternative approach That is to include a clause in the general conditions of government contracts relating to where a person has been convicted under the Act, for that to amount to an act of frustration or grounds for termination. We noted the reference to the lower form Frustrated Contracts Act. I'm not sure that's a correct name, but anyway, and its provisions for treatment by the court to allocate the risk of that event in a way that seemed justified, and it was recommended as an approach to be followed in this regard. It was stated that if a person was convicted under the Act, had a commercial or financial interest in any public contract, license, concession, etc., that would trigger an obligation on the court to consider making an order to treat that contract as frustrated or at an end, or making any consequential orders that may be required in the interest of justice to protect innocent third parties, including financiers who may have provided financing on the basis of the contract, among other things. Subsequently, we were advised by the officers of the Parliamentary Council that the provisions of the Proceeds of Crime Act address the matter as any property is liable to be forfeited under the Proceeds of Crime Act. Your committee does not accept the recommendation. 23. Yeah.
Good night, sir.
So are we not going to say anything about this, though? I mean, this is a really important issue, you know, and I think, shouldn't the committee suggest that the Public Procurement Act be amended to address this thing, or that there be a standard policy that there be included in all government contracts a provision providing for termination in the event that the contracting party is convicted of a crime under the anti-gang, or any legislation scheduled to the Poker Act in the second schedule of Poker or something. I just feel uncomfortable with just saying we don't accept this recommendation when this is a fundamental issue about how the state's resources are appropriated to the empowerment of organized crime. We can't just leave this so.
I think what is captured really has not accurately reflected the discussion that took place. The issue under discussion is when, forfeiture of asset upon conviction, where a party, the convict is party to a government contract. And issues, the discussion, if I recall clearly, spoke about the need for a procedure to determine the rights of innocent third parties. But as you said, Member Golding, is a critical issue. It isn't that it was rejected outright, but it was being looked at where else could it be provided for. And the amendment to the Public Procurement Act, as well as determining procedure for the termination of the contract. Much of the discussion, I think Member Knight had weighed in a lot of the consequences where a contract is being performed midway and what that would do, but it certainly, I do agree that it can't be left hanging like this.
And Chair, if I may just add, I think there are two different issues at play here. One is to do with the forfeiture of assets on conviction. We have a robust system already in place under POCA for that. And we've now scheduled the anti-gang legislation to POCA so that convictions under the anti-gang legislation are brought under the POCA regime. You did that last year, I believe. Okay? So that's one issue. The other issue, which I think is more what this discussion in these paragraphs is addressing, is what happens where persons who are involved in organized criminal activity are benefiting directly or indirectly to state contracts and licenses and permits, so that the public resources are empowering their activities. And how do we address that? And I think we have to say something that would enable, you know, whether it be under the Public Procurement Act or however it may be, there must be a mechanism for bringing those arrangements to an end and the court making consequential orders to protect the interests of innocent third parties. This is not an unusual scenario. This is something that the courts have to do from time to time. Even under POCA, where you forfeit assets, and there are innocent third parties that may have bought the asset and not yet had title transferred or financed it, and the law requires their interest to be taken into account. So this is not a new dilemma that the courts have to grapple with. And as was said in the Law Reform Frustrated Contracts Act, or whatever that's called, where a contract is frustrated, let us say, for example, because of some supervening event and it can't be performed, the court has to determine how that is worked through in terms of the consequential issues that arise. So this is not something that is beyond the courts to address. Yeah.
I suggested, therefore, that language to the effect that the committee recommends that some provision be made either by way of policy or law for the termination of contracts where contracting parties convicted during the subsistence of the contract, with provisions for the protection of innocent third parties. Something to that effect.
I mean, I don't see how policy could deal with it, in the sense that there has to be a legal provision.
No, when I say policy, policy meaning that it would be a standard clause of the contract, as opposed to it becoming a provision of law.
Right.
But it would escalate up to law because it would be a contractual clause.
Right.
In the circumstance.
Understood. Though I must say I prefer a legislative solution, because you may well find that particular agencies forget to include it, or deliberately don't include it in when it matters and so on. So to me, it ought to be a legislative provision.
Even before we get to the law, we would have to clearly articulate the policy, because it is a policy that then informs what the legal position would be, and to look at how it would be done. But yes, I think at the high level would be better, but you still would have to start at a policy.
Amend the first paragraph and add it to the first paragraph of this part.
The recommendation, Chairman.
So I think the section should talk about forfeiture of assets upon conviction and termination of government contracts in which convicted gang persons participate or something. And then the recommendation would be formulated that a policy should be speedily developed, leading to legislation to address the issue of terminating government contracts which are tainted by involvement of gang participants or something like that. Yeah.
Just want to tighten up the language, because we're going to add this to it and circulate it without another meeting. But I do agree with you that we have to have something in here. This is one of the contentious issues out there. Something has to be added to indicate we need to have a legitimate mechanism of terminating contracts in which the gangsters become involved in.
So, new provisions: assaulting a police officer in lawful. Oh, sorry.
I'm just trying to wrap my head. Suppose the contract is with a limited liability company, because I see reference to shareholder, and the person is not. Although this refers just to major shareholders, but suppose there is a person who is convicted who is a shareholder who is not necessarily the major shareholder.
I think there must be some idea of material shareholding, and I think it is at the risk of the company and its other shareholders if they are facilitating investment by persons who are involved in this type of thing. I mean, right now under our companies legislation, you have to file beneficial owners of companies and go back to the ultimate beneficial owner. That was, and I believe the Minister of Finance is coming to the House today to talk about these issues again because of the pressure Jamaica is under. So this is a very serious matter for us, and I think it ought to include situations where there's any kind of material, and I would say, 10 or 15% would be an appropriate threshold of materiality, and it should be direct or indirectly held, because persons will put things in their mother's name or their baby mother name or whatever,
Could I just ask a question here? Are we here contemplating a situation where on conviction, the convicting court goes into these issues?
procedurally, I think that we'd have to look at the best way to do it. Whether that's the most efficient way, or whether there has to be some referral to another tribunal or what.
Yeah,
but you want to make it, you don't want to make it too cumbersome.
You don't want to make it too cumbersome, but you don't want to really burden the convicting court with this kind of issue.
So you want to bear in mind that you want to reduce multiplicity of proceedings, and where a court is better informed, a particular tribunal is better informed to make consequential orders administratively, that's a better place to do it.
Courts don't make administrative orders of that nature. And when you're looking at this is a complex matter. You're recognizing rights of third parties, etc. So I think we seem to be looking at it more so from the punitive approach. But no.
Could we give the trial judge the discretion whether to deal with it him or herself, or to refer the matter to the registrar to be set before another tribunal to be addressed, and kind of leave it? Because if it's relatively straightforward, it may be something that the trial judge would be minded to do, or if it's complex, it may be something that they may want to.
But even though, on conviction, there are some instances where forfeiture. Proceedings. Right.
And so restitution. We have restitution as well in some, like under the human trafficking, there's restitutionary orders which are mandatory.
So this is something that has to be looked at. Policy, procedure, law.
Yeah.
Chairman, all of those details wouldn't be determined here. The broad recommendation would be made, and the work would then be done.
I need to get the language clear for.
So it would be the provision for the termination of contract with all of the convicted contracting party during the subsistence of the contract, and also provisions for the protection of innocent third party, which the system is already well familiar with.
Yeah, and I would just add, and the provision should also address situations in which there's a material shareholding in the contracting party held by or on behalf of the convicted person. Yeah.
All right.
Yeah. Okay, new provisions, assaulting a police officer in lawful execution of his duties. Your committee notes a proposal from the Office of the DPP regarding assaulting a police officer in lawful execution of his duties, specifically to incorporate a provision to criminalize the act of preventing an officer from lawful execution of his duties, coupled with the appropriate sanction, which would act as an effective deterrent. We note Section 30 of the Constabulary Force Act, which provides for the offence, and further note that the fine was increased to $1 million by a consequential amendment to the ZOZA legislation. This offence is of general application. Your committee does not accept the recommendation. New provisions.
But it wouldn't be a consequential amendment to the Law Reform Act.
Made by.
Right.
Made by, rather than to, yeah. New provisions to be included. Pre-charge detention. Your committee notes the proposal from MOCA, the JCF, and the ODPP for pre-charge detention for a period of 7 days, possibly extended to 14 days. Your committee does not accept the recommendation and notes that the issues related to pre-charge detention are being examined in the revision of the Bail Act and would be revised therein. Yeah, I mean, I think we say we were told that. We were advised of that, right? Because we wouldn't know that.
The work is going on, yes.
Huh?
Yes, it is.
Yeah, so could we say, and notes that we have been advised that.
Right.
The issues relating to pre-charge, etc., yeah. New provisions, production inspection orders. Your committee notes a proposal from the JCF for a provision that allows the police to apply for production or inspection orders and account monitoring orders in furtherance of the investigations under the Act. In our deliberations, it was highlighted that the POCA would have already made it an offence for bank employees who are in receipt of production orders from the law enforcement agencies to tip off the customer of the bank. Section 21, 1 and 2 of the Cybercrimes Act provides for production orders, particularly where a device or an information is required, as well as that the order compels the owner to, among other things, provide passwords, etc., in relation to electronic devices, and an offence is committed where the person fails to comply. It was further highlighted that Section 12 of the Interception of Communications Act and Section 17 of the FID Act had similar provisions. Your committee does not accept the recommendation and notes that this was already provided for in various pieces of legislation, particularly the Process of Crime Act, the Cybercrimes Act, the Interception of Communications Act, and the Financial Investigations Division Act.
I think there was a recommendation as we spoke about a suite of investigative tools, and this should be included as a standardized power, notwithstanding that it is present in other pieces, but as a general tool should be available to the police.
We seek to amend into this in the JCF Act as a recommended consequential amendment.
The idea was expressed that it would be useful in investigating these types of crimes if a single application could be made to the court to avail the investigative body of one or more of a number of options, including things like intercepts, access to financial records, tracking persons who are crossing borders, and that sort of thing. So that rather than have to make a separate application on separate occasions under separate pieces of legislation, it could be done under one procedure. And so that was what I think was discussed. I believe what the AG is saying is that what is being discussed here would be subsumed as part of that. Part would be included in the procedure if there's to be a single procedure to access this menu of investigative tools. Yeah. I think we should, yeah. All right, new provisions, mandatory minimum sentences for repeat offenders. Your committee notes the proposal from the Ministry and MOCA for the inclusion of mandatory minimum sentences for repeat offenders convicted under the legislation. In the deliberations, we raised the issues of dealing with the habitual offenders and the mandatory minimum sentences. Things to be reconciled included the high recidivism rate and the provisions in the Criminal Justice Administration Act that dealt with habitual offenders. Your committee does not accept the recommendation. New provisions to be included in that. Yeah. New provisions to be added. Restitution. Your committee notes the proposal from the Ministry and MOCA for the inclusion of provisions for restitution, similar to what is included in the human trafficking legislation. During our deliberations, we noted that the lot of scamming legislation included a provision for restitution, as did the human trafficking legislation, which was passed fairly recently. Nevertheless, we were advised that the Criminal Justice Administration Act 2018 provides generally for restitution, which is to be applied whenever a person has been convicted of any criminal offense. Your committee does not accept the recommendation. Yes, so the point is there is already an omnibus provision in the Criminal Justice Administration Act for dealing with restitutionary orders.
If we're going to put the act as a 2018 act, if you're going to just specify the amendment, then you would have to put it. If you're going to put it as a general act, it wouldn't be a 2018 act. It's read and construed as one with the principal act. So it wouldn't be 2018. It would only be 2018 if you're referring to the amending part of it.
Yeah. So we could just say we're advised that the Criminal Justice Administration Act, as amended in 2018, provides generally, etc. New provisions, declaration of a criminal organization. Your committee notes the proposal from the Ministry and the JCF for a new provision formalizing the declaration of an organization as a criminal organization. In the deliberations, it was noted that in order to make such a declaration, it would have to be established as a fact by a procedure that had due process and where the standard of proof was a criminal standard. Your committee does not accept the recommendation. New provisions, use of control orders. Your committee notes the proposal from the Ministry for a new provision regarding the use of control orders on suspected persons, similar to what happens in South Australia. During the deliberations, it was noted that the recommendations had been included in the schedule of the ZOSA bill. They were withdrawn to allow for further consideration, and thereafter agreed that the Ministry would present these recommendations to the committee. We noted that the chambers had undertaken research on control orders, and there was controversy surrounding their use in England. The UK has had a history of using control orders as part of the response to terrorism, etc. And the experience has been controversial in terms of legal action taken with cases before the Supreme Court of the UK. The legislation was not challenged based on compatibility with their human rights regime, but on the specific application of the control orders. It was noted that a control order placed limits on the free movement or travel of the individual, as well as the ability to communicate freely with others. The UK has since repealed and replaced sections of the legislation, and the new regime has not been challenged nor used much. It was further noted that the application of a control order regime in Jamaica could pose a challenge, taking into account the Charter. It was suggested that a watch list be pursued administratively. Your committee does not accept the recommendation, but recommends that the Ministry should continue to pursue the watch list administratively. New provisions, use of unexplained wealth orders. Your committee notes the proposal from the Ministry for the inclusion of provisions for the issuance of unexplained wealth orders on suspected individuals. Your committee does not accept the recommendation and notes that the matter is to be reviewed within the context of a wider review of the Process of Crime Act. I think rather than say did not accept the recommendation and notes, I think the point is we didn't accept it because we were told that it's already being addressed by the other procedure. So perhaps it could just say your committee does not accept the recommendation as the matter is being reviewed within the context of a wider, it's not that we rejected the idea. New provisions, organized criminal registry and watch list. Your committee notes the proposal from the Ministry to establish an organized criminal registry or watch list for persons charged with or convicted of offences under the Act. Your committee does not accept the recommendation, but recommends that with the support of the Legal Reform Department, there was need to bring the work of examining the existing piece of legislation that deal with a wide range of matters forward. These include how ex-convicts are dealt with during the period of rehabilitation when they continue to be threats to society, and the methods of monitoring these persons, how persons are dealt with between the stages of being suspected of committing an offence and being charged with an offence, stage after charge and prior to conviction, an examination of the requirements across all the areas of monitoring and what may be required specific to certain types of conduct.
Curiosity, why is it an ex-convict?
An ex-con. Yeah. Yeah. And what are we calling the period of rehabilitation? What are we calling the period of rehabilitation here? Is that is the period of rehabilitation for the expungement period? The period of the rehabilitation period here referred to, is that the same as the, because in the expungement legislation there's a period after, or is this meant while you're in prison? I just wasn't sure what this rehabilitation period is.
Here is, all right,
So the word should be convict and not ex-convict.
but not quite now. Let me get a better understanding of what we're saying here, that we should use existing legislation to do, I'm not clear what we're coming out with here with.
If you recall, when the recommendation was made by the Ministry, it really did not take into account that there's already provision for registration of convicts, and so there was some lack of clarity as to exactly what it was intended to, the recommendation was intended to achieve. No, like
think maybe we could just say your committee felt that this proposal wasn't sufficiently developed to be taken forward at this time and recommended that it be reviewed by the Legal Reform Department, and just kind of leave it at that. We don't need this long stuff here because some of it I don't even know what it means. So this is really like a two sentence, the first sentence and the second sentence, and we're done. The first sentence is there, the second sentence, the committee felt that this proposal wasn't sufficiently developed to be taken forward at this time and recommended that the matter be reviewed by the Legal Reform Department. General recommendation. Your committee recommended an amendment to the first schedule of the Interception of Communications Act by way of an order by the Minister of National Security in accordance with its provisions. This was subsequently done in July 2019, which allowed for warrants under the Interception of Communications Act to be issued to prevent or detect offences under the Act.
Who issued the warrant? The warrant that issued by the court.
It just brought the anti-gang legislation under the intercept system, so you could, like drug offences already are and so on. Offences to be added to POCA. Your committee recommended an amendment to the second schedule of the Proceeds of Crime Act by way of an order by the Minister of National Security. This was subsequently done in July 2019 to provide that offences under the Act. Really, no, it's just this was done in July 2019.
It really should say that the recommendation was taken on board and implemented because it came out of this, and since the process is a simplified process by way of order, it had been accepted and implemented by the minister.
Yeah, the first sentence though doesn't really make it clear. Your committee recommended an amendment to the second schedule of the Postal Crimes Act by way of an order by the minister
should be noted.
to include the include offences under the anti-gang or the Act, right? As so as to bring them under the POCA umbrella essentially, and that was done in July 2019. That order was made. Witness protection. Your committee recalls that the issue of witness protection was not dealt with extensively in our deliberations. We noted the matter of challenges with providing secure interim protection and accommodation for witnesses in the witness protection program and the implications for successfully prosecuting gang-related cases. It was noted that the prosecution of a major gang was recently discontinued because the main witness had become unavailable. This raised a question as to the reasons why the witness was not adequately protected. Your committee recommends a review of the Justice Protection Act with a view to amending that act to address matters such as expanding the category of persons who may be afforded protection of the Witness Protection Program to include persons who have committed offences under the Criminal Justice Suppression of Criminal Organizations Act. Wouldn't just be who have committed, would it, or who have been charged?
Actually, persons who are witness who under the plea bargaining system who would have become a witness to turn over, or right.
Law doesn't allow for them to be protected.
I think there were two issues that were raised. Among the many issues, two were highlighted: the adequacy of it and whether it should include persons who were either themselves being charged or had convictions.
Law doesn't allow for us to protect those, and it's still voluntary. Because bear in mind, the way it's worded, well, I won't change it, but the fact is that the JP have not lost any of the witnesses who have come under witness protection. We have not lost anyone who have remained within the rules. Those the gentleman who we lost did not accept protection, and
you'd even discuss whether there should be mandatory protection for key witnesses.
We'll look at introducing that into the legislation.
The wording here still is a little confusing for me anyway. Was this referring to persons who have been convicted under the anti-gang legislation?
Chairman, I think it really should say that during the course of deliberation, the committee was advised of the difficulties encountered in the case before the court, which was discontinued due to the unavailability of the witness and his refusal to accept protection in the witness protection program, and then the recommendations, because that is how it was specifically introduced.
That person wasn't a convict. That person was at large.
That person was an alleged member of the gang,
Right.
Former member of the gang. But the discussion went beyond that to look at the deficiencies in the program, bearing in mind other cases that were too.
Right, there are two cases. There are two sectors. There are those who have been members of the gang who have been charged and convicted and have decided to become state witness. There's necessary protection of those individuals, and there are those who are members of the gang but refuse protection. Right? And that is where it would come to
Maybe
mandatory.
this sentence in bold, your committee recommends, where it says, expanding the category of persons who may afford the protection of the witness protection program, and it goes on to say what, to include what. I think we just need to be clear.
Consideration should also be given as to whether there should be compulsory.
Right.
Anyone should be compulsorily brought into witness protection. I mean, it's the issue of competence and compellability, but...
No, but how do you compulsorily bring someone to the witness protection? That's not possible. No. If the person has not committed an offense...
No.
Wait a second. If the...
Conceptually, you may do it because
No.
you may compel a competent witness. And
No. You compel to give evidence. If a person has not committed an offense, how dare this... Let me finish.
That is why it would have to be thought through. That's why the consideration would have to be given in light of what was
So
raised.
you're saying that you're abandoning your position and say we must think it through.
I'm not abandoning the position
Well,
at
then
all.
I have to address it.
Please go ahead.
Because I don't know how you're going to compel someone who has not committed an offense to be part of a witness protection program. That's interference with constitutional rights.
Yeah. I can't actually see how that could work in practice either. Maybe if they were themselves a suspect, as part of some plea deal or something, you could, they'd have to agree to it as part of the plea deal. It wouldn't be,
If they are being charged or have been convicted, that's easy. It's the ones who have had no charges at all or no suspicion that you'll have a difficulty.
I don't think you can only have a carrot, you can't have a stick,
Right.
In terms of mandatory protection, a man can't.
Discussion had taken place, was reflecting what the issue had arisen.
Yeah.
It was not necessary that a recommendation was being made.
But we're in the recommendation sentence here, so just to help the author of the report, or the amanuensis of the authors, just to say, to include persons who have been charged or convicted under this legislation. And,
A person...
I'm not sure why they can't be, but we were told there was some gap. Yes.
We don't need to do the acknowledgements.
Right.
Can we then look at, we'll have to look at the attendance side. We'll look at we will take a look at the amendments now.
Chair,
What do you
it's
think?
kind of difficult to go through these amendments without having the actual act. Because, there are things like in paragraph A do this and in paragraph B do that. So, that's difficult.
What suggestion then we circulate it and
Chairman, Madam CPC could assist us with this part of the report.
Actually, it's not as long as I thought.
Right.
Yeah. It's not.
I think
So where we're going now?
We're on the page 30.
the CP. Can we have full attention for the lady as we are trying to tidy up in a short time?
Thank you, Chair. So the first amendment to Section 2 is really a consequential amendment which flows from the decision to relabel what was formerly defined as serious offenses as applicable offenses. So where the word serious appears in definition of criminal organization, we are now removing that and substituting it with the word applicable.
Could I just ask a question? Was that to accommodate the concept of criminal pickpockets? A criminal gang of marauding pickpockets, and we didn't accept that. So is this amendment still necessary?
This amendment is solely to facilitate adding to the schedule types of offenses that would not normally be considered serious offenses. So the example of which was given to us was larceny, I believe, and receiving of stolen goods. So that, and we had a long discussion about whether we wanted to make, very petty criminals who like pickpocket rings and so on, bring them under the anti-gang organized criminal legislation, which is really supposed to be dealing with, much more serious criminals.
The thinking was that, remember, some gangs organize their the younger members or their peripheral members to be involved in that kind, from windscreen wiping to sale at stoplights and that kind of stuff. It's part of their structure. The idea was to try and bring those in. So you want to bring it in without actually just implicating 2 or 3 youngsters on the street who are just, they're still pickpockets, but they're not in an organized gang. That was the thinking, because gangs do have this.
In a way, it's a cop-out, because it's a cop-out in the sense that these organized gangs are doing serious things, but they're also doing some things that would not normally
which you can catch them.
Yeah.
I mean, the guys who are selling on a particular street corner is controlled by a group of gangs who supply them and then have them sell at a commission. And that was the idea, is to incorporate all of that in the operation, in the law.
Paragraph 2, so the current definition of law enforcement officer includes that law enforcement officer means B, a member of the Island Special Constabulary Force, and in keeping with the recommendation that this paragraph be deleted because the merger of the force has been completed administratively, we are deleting paragraph B of the definition and renumbering the paragraphs accordingly. 3, we're deleting the definition of serious offense, again in keeping with the decision to replace the terminology with reference to applicable offense. And so paragraph 4 inserts the definition of applicable offense to mean an offense specified in the first schedule. Amendments to section 6. Paragraph 1, again, in keeping with the decision to change the terminology, we're deleting the words a serious from subsection 1B and substituting, therefore, the words an applicable.
Could I suggest, CPC, we understand that, skip out all of those and just go to the other ones. Yeah.
Right. Paragraph B deletes the word and in keeping with the decision that was made that it was not necessary to have the conjunctive in that section. The amendment listed as 2D, we're inserting here as paragraph H, any symbols or markings, whether in the form of tattoos or any other item or on or in the possession of the person that indicate a link or involvement with the criminal organization, and that gives effect to the recommendation to include the symbols or markings as part of the factor. So that would be considered in determining whether a person is a part of a gang. Section 7, again, deleting the word and. Section 8, similar decision. New section 8A, in keeping with the decision to include a provision similar to what was in the Lotto Scamming Act, where a person is in possession of property that cannot be accounted for. 8A, in a trial for an offense under this act, the fact that a person A is in possession of property for which that person cannot satisfactorily account and which is disproportionate to the person's known sources of income, or B, had at or about the time of the alleged commission of the offense obtained an accretion to the person's property for which the person cannot satisfactorily account, may be taken into consideration by the court and is admissible as evidence to the extent relevant to any issue in the trial. Section 11. This gives effect to the recommendation that 11 be expanded to include the circumstance where a person is acting on behalf of or on the instruction of a criminal organization. So the provision has just been reformulated, and it now reads: 1, a person shall not, in order to gain a benefit, profess to be a part of or a participant in a criminal organization or to be acting on behalf of or on the instruction of a criminal organization, whether by, the paragraph, there's an error in the number in there, that should be A, telling anyone that the person is a part of or a participant in a criminal organization or is acting on behalf of or on the instruction of a criminal organization, or B, otherwise suggesting to anyone that the person is a part of or a participant in a criminal organization or is acting on behalf of or on the instruction of a criminal organization.
Can I just get a clarification? Otherwise suggesting. Yes, please. Well, I wasn't here when this particular provision was being looked at. Otherwise suggesting, could you say what would that contemplate, please?
That's not a change here because that was part of the original
Pointing
formulation.
to your tattoo, pointing to the skull, that's the teardrops were tattooed under your eye, or that's pointing to the tattoo on your arm. Oh, I don't know. I don't know. I'm just suggesting that there are ways of communicating things other than by what you say. And so I think that was what the original provision was. And as the CPC has said, this is not a new one.
Section 15, this expands the categories of things that might be considered aggravating factors in sentencing. So subsection 2 is being deleted, and we're now including expanded provisions. Section 4, where the offense is committed by a person on the premises or grounds of or within 300 meters of a school, or involves aiding, abetting, inciting, or inducing an act of violence as part of the process of recruitment. B, an offense under section 10.6 as relates to a contravention of section 10.3 or 4, where it's committed, where an offense under section 10.6 as relates to a contravention of section 10.3 or 4 is committed and the person incited or induced is a child. And 10 is the offense, is the offense of knowingly aiding or abetting a criminal organization or becoming an accessory for the fact in the carrying out of a serious offense by a criminal organization or harboring or concealing a person, knowing that the person is a part of or a participant in a criminal organization, or promoting or facilitating criminal activity of a criminal organization. Okay. Also, an aggravating factor is an offense under Section 12 where it is committed against a child by a person on the premises or grounds of or within 300 meters of a school, or where the offense involves committing, aiding, abetting, inciting, or inducing an act of violence in order to prevent, deter, or obstruct a person from ceasing to A, be part of or a participant in the activities of a criminal organization, or B, provide a benefit to a criminal organization. D expands to make aggravating factors any offenses committed under Section 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, or 13, where they are committed by a person who, at the time of the commission of the offense, has in that person's possession any item of dress, designation, or description of a law enforcement officer. E expands to include as aggravated offenses for the purposes of sentencing any offense under Section 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, or 14, where the offense is committed by a person who is at the time of the commission of the offense not a citizen of Jamaica.
Is there any reason why 14 is in one of the lists and is not in the other?
Yes, 14 is the offense relating to impersonating a police officer. So Section D refers to basically having in possession, which is itself the offense under 14. Right. Section 17. This implements the discussion having regard to whether the court could order protections for the identity of a witness or after a trial has started or at any stage before trial. So the provision is being extended here to provide that the court may at any stage before or during trial order the protections. So accordingly, the marginal note is being expanded by deleting the current marginal note, which refers to trial procedure, and substituting, therefore, the words mode of proceeding. Then in subsection 2, so the current subsection 2 provides that in the interest of the administration of justice, public safety, public order, public morality, a court hearing a case in the exercise of its jurisdiction of the Act may direct that, and then A and B goes into the protections. A, B to C concerns the protections. So we're expanding those words in the chapeau now to provide that the court in the interest of the administration of justice, public safety, public order, or public morality, a court hearing a case in the exercise, a court that has jurisdiction to hear any case under this Act may at any stage before or during trial make any of those orders for the protection of the identity of a witness.
This is square bracketed. Any reason why?
Because I noticed it was not referenced in the report, but it was a decision that I had according to my notes.
So is it now referenced, or we need to reference it?
I didn't recall. I think it should now be included.
In the discussion on Section 17.
Mm-hmm.
Yeah. One question that just occurred to me while you were reading it is, should this be expanded? Should there be a post-trial ability to act under this section? I don't know. I'm just throwing it out. It says before or during. But if somebody is at risk in some way, should they be possible to make on the court to make some kind of order that would protect that person's identity or something going forward?
that again is sounding more like Justice Protection Act, because this provision is really just dealing with, so it was saying trial procedure, but so matters before, interlocutory, everything before and during trial. Afterwards is not within the remit of this provision. I'm not saying that perhaps you want to discuss a discrete provision dealing with protection, but normally those kind of matters I think would have been or should have been addressed under the Justice Protection Act. It's just that even in the discussions of the committee, we realized that there were some gaps with the Justice Protection Act, and it was a recommendation for that act to be reviewed.
I just want to see if I understand what you are saying. You are really wanting to give a power to the court to to have provision made for protection for someone who has been involved in the trial.
Yeah, my thinking was, let us say the order that was made was that this person's identity should not be revealed in any media, for example. Yeah? And they were a key witness in the matter. And the trial came to an end. You know, I would have thought that that person would want the assurance that their identities would be protected going forward. Yeah.
Assurance from the court.
Yeah, from the court having the jurisdiction to make that in an order under this section. So I'd have this section 17 before me, but it just seemed to be a dealing with a jurisdiction that would enable the court, in relation to proceedings under this legislation, to ensure that persons participating in the trial can be protected appropriately. And I just wondered whether that should not also extend to post-trial situations. I'm just throwing it out because I wouldn't want there to be a gap which we could have fixed by just saying the word or after, just inserting the word or after.
And under the Justice Protection Act,
Right, but just to recall the context in which this recommendation was made, concern was that once the proceeding commenced, the court did not have the power to grant that. There are also different rules that apply in relation to the powers of a court once a matter is concluded.
Yeah, I mean, the wording that's being changed now in subsection 2 is in the chapeau, I think. In the interest of administration of justice, etc., a court that has jurisdiction to hear any case under this act may at any stage before or during trial direct that. And then it's things like the identity of any witness. I mean,
just to say, Chairman, if that issue were to arise, then during the proceeding, the order could be made to extend to what reports are made afterwards. But at the conclusion of a matter, the court becomes comatose. Yes, and it ends.
I accept that. So I'm wondering, is it sufficiently clear, for example, that an order that was made before or during could continue to have effect after? That the order would continue to have effect?
The terms of the order would need to determine that.
Would the jurisdiction to do that exist without the wording? I'm just. Would the court have jurisdiction to make an order that lasts after trial?
Member Goulding, what you're saying, that the court should be empowered in circumstances where an issue may arise post-trial regarding the identity of a witness, for there to be some restriction on the disclosure of the identity of a witness whose identity during the course of the hearing had not been disclosed.
Yeah, what I'm saying is, let us say there's a very sensitive and vulnerable witness whose identity is to be preserved, and an order is made to that effect during the proceedings. I would want it to be worded that the court could word it that preservation of the person's anonymity should last post-trial as well. I'm not suggesting that the court can make an order after trial, because the court is functus at that point, but that the order made during the proceedings could continue in effect after the trial, so that the person's anonymity could be preserved if that was the order that was made, not just during the proceedings, but in perpetuity.
sorry, member Golden, 17 C, 17 2C, wouldn't that cover it?
I don't have it there. What
It
is
says
that?
no particulars of the trial. Is that there? Because I have it on page 18. I think they made up section 17 is quoted on page 18 of the report,
But just to
which
say,
says that no particulars of the trial other than the name of the accused, the offense charge, and the verdict and sentence shall be published without prior written approval of the court. That seems to...
Chairman, I
So
understand the point
if
being
the
made,
order
though.
is made within the court, then it continues under 17C.
But I just wanted to be clear that, that the life of the order doesn't end at trial. That the life of the order would continue, notwithstanding the trial is complete. That's important.
The point is understood, Chairman. And Madam CPC, we could look at a language that would, should the need arise, enable the court to make the order in such a way, even though the court is at liberty. At the end of the day, how it is construed will depend on how it is worded. But I understand the point, because the need may indeed arise in very sensitive matters where, you know, witnesses, victims are all part and parcel of the criminal network. And so issues of safety may be of concern post-trial. So just the language too. End of the day, it would fall to the parties before the court to ensure that what is being sought and what has been ordered by the court capture deals with the mischief at hand.
CPC, but we're on some board time, you know. I think
Chairman,
another convening
we may have to look to see how it can be done and if it is already captured. I don't know, Madam CP.
So who know? I just want to understand.
You may weigh in, Madam SG.
I just want to understand it. These orders of non-disclosure usually apply to news media. Right. So now it persists after.
Social media.
Yeah. What happens there? Someone who but they don't know. How would I know? I just want to understand.
Issue of enforcement is another matter, separate and apart, because if we are to go down that realm.
No. You don't make silly orders that can't be enforced.
But it's a court that will make the order. The issue under consideration currently is whether the legislation should be cast in such a way that it does not restrict the power of the court to make an order that would affect post-trial issues.
And that is what
so
I'm
that's a
dealing
separate
with.
point.
No.
For example, though.
No. I don't want to be contentious with the Attorney General, but there must be an ability to think from A to Z. The fact is that here is a situation where the court makes an order and it persists after the trial. That order relates to whom?
Whoever's within its scope. So let us say, for example, the order is that the identity of this witness shall not be disclosed in any media.
In any media?
In any form of media.
So the media would be bound?
They would be bound by it.
And that's what...
It's just in a way, for example, a permanent injunction granted in a civil trial. The trial ends and the injunction lasts permanently.
Yeah, but
if it's breached, then you go back to court to enforce it.
Yeah, but that's for the parties. They know. You follow me? So right, and that is where I'm having the difficulty as to who is bound.
I think anybody that the order is expressed in terms of would be bound by it. So if it is directed at me, I am bound by it. If it's directed at a category of persons that you fall within, you're bound by it. And the question is, for example, if you breached it after, who would bring contempt proceedings to enforce it? Well, I think the DPP would be able to do that, because that would be a breach of a court order, which would be enforceable. So I think the DPP's office would be able to bring contempt proceedings for having breached that order.
I have to look at it a little closer.
Chairman, I think we are coming up on a time boundary in respect of the other committee that is scheduled to sit. And although we are making quite a bit of progress, I would respectfully suggest that we take note of the discussion in relation to the suggestion on this matter and just go forward.
Well, all I'm asking is that it be clarified that the orders can last beyond.
So, and that would be a matter for the Chief Parliamentary Council by way of drafting.
So moving on then?
Yes.
So moving on to first schedule.
Sorry. Item 3 for the amendment to section 17 increases the penalty on conviction for the offense in RM court from $1 million to $3 million. First schedule adds to the list of offenses which are now termed applicable offenses an offense under section 5 of the Larceny Act, which is simple larceny, and an offense under section 46 of the Larceny Act, which is receiving.
So some of us had a real concern about this. Some of us felt that while we accepted that it might be convenient for the prosecution because they can prove activity in the area of simple larceny or receiving, to have it included within the applicable offense umbrella. It also has the consequential effect of allowing petty organizations doing petty things of a criminal nature to be charged under the Anti-Gang Act, which is it is extending the jurisdiction of that act and its scope, which is intended to deal with serious criminal activity, to a new domain which it was never contemplated as extending to. Some of us have a problem with the effect of this amendment, in that it could be misused by the police and by prosecutors. We haven't decided yet how we will address that, but we do have this concern, Chair.
It's a repeat of the first item, but I think I said the context was that gangs who engage in simple it will have to define the schedule, simple activities that are part of the gang operation. So when those activities become part of a gang operation, then they are brought under this legislation.
It's not quite that. Let me explain. If you're listed in the first schedule, if the offense is listed in this first schedule, if any 3 or more persons come together to do it, then they become a criminal organization for the purpose of the legislation. In other words, it is the first schedule that is the actual platform of what defines a gang or criminal organization. You have to be coming together to do one of these things to become a criminal organization. So once you include in that list petty things, you mean that the participants in petty things can become gangs for the purposes of being prosecuted under this legislation, and that's the concern that I think we have. Yeah.
Chairman, I thought we had responded to that concern when it was raised, because the offences have to be designated in the first schedule. The power to do so is granted to the minister by way. Yes, but there was no discussion or concurrence to include the pickpocketing, for example. And when we looked at, it's a matter of technicality, because we looked at some of the offenses that were considered serious, that at the end of the day would have the same penalty as this offense, for example, the lesser offense of receiving. And so the whole idea was to ensure that because of how offenses are categorized, by way of technicality, we wouldn't have a repeat of what took place. But at no time was it contemplated that it would be watering down the seriousness of what would be contemplated, because the minister wouldn't be designating those kinds of smaller offenses. Even though, Chairman, we must say that there is something counterintuitive, you know, because sometimes we disregard the fact that people commit minor offenses with impunity, dominate a space, terrorize people, and in so doing, they build their, you know, criminal might. But I don't think I don't think the concern would materialize because those petty offenses would not be designated in the schedule.
No, but they are. Simple larceny is being designated in the schedule.
But larceny, though it's called simple, it's not necessarily a simple matter.
It is not
the gravity,
necessarily.
right.
It is on a spectrum.
Right.
But at one end of that spectrum is very petty theft, which is an offense. No one is denying that it's an offense, and people should be prosecuted for committing those offenses. Yeah. The question is, should persons who are in a relative, in a gang, a group of pickpockets who go around, should they become amenable to being charged under the anti-gang legislation, which is what the effect of putting simple larceny in the schedule, that's what the effect is. So,
as I said, theft is a part of the gang operation. It's how we get it in here, so we'll have to look at how we get the wording in.
I agree that we should send a message to the society that legislators have come to the view that some pickpockets by the street are as dangerous to the society as these gangs who travel around with their guns, killing people, cutting their knives, cutting off people's head, doing all those sorts of things that equate them. And
not
the society
quite,
will feel,
that's not quite an accurate
the
reflection,
society
because
will feel satisfied that we understand what we're dealing with in separating very serious matters.
No. Which serious matter with a gang, organize a gang too, especially in some areas where there's the gang leaders. Now, if you organize a group of people to do pickpocketing, to stealing, to rob, and to use the money to buy guns, that's what you're talking about.
That's nonsense.
That's not nonsense. That's a reality.
Total nonsense.
Right?
Nothing like that going on.
Anyway, we have to wrap up at this point. Yeah. The suggestion is,
we don't need to come back here. There's just the tipping off offense, and there's a general cause
just in relation to the tipping off offense.
Yeah.
Just to say that.
You're suggesting you don't have to come back, Member Golding? So we'll circulate this after.
Right, but Chairman, I was just suggesting an amendment for the tipping off offense. If you go to the offense creating provision, that would be 39, the proposed new 39A3. The parish court, it should be 5 years, not 10. There are some words in square brackets because the parish court jurisdiction. Also, there are some words in square brackets, and I would suggest that we remove the square brackets, that it should attract both, so it can be either fine or custodial or both.
This would definitely be beyond what is contemplated for the custodial jurisdiction of the parish court. So, yes, I think it makes sense.
All right.
Yes.
So, as we adjourn, the proposal is to...
And then just one other thing, the proposed amendment to the Constabulary Force Act. The committee needs to take a decision as to whether the warrant would be issued by the Justice of the Peace or a judge of a parish court.
It currently is not. It says either. Isn't that what 17A2 is saying?
And I'm suggesting it really should be one authorizing entity. So I'm suggesting you should take a decision as to whether the JP or the judge of a parish.
Administratively, the JP would make better sense, Chairman.
If we adjourn now, we're going to have the clerk make... So,
wait, Mr. Bailey wanted to just make a point.
Yes. Yeah. In the proposed amendment to insert the search and seizure section in the Constabulary Force Act, we have some concerns about subsection 11 as proposed, which states that a warrant under this section authorizing a constable to carry out a search may be executed by the constable, notwithstanding that the warrant is not in the constable's possession at that time, and shall, on the demand of the person apparently in charge of the building, receptacle or place specified in the warrant, be shown to that person as soon as practicable. We are unaware of any similar provision in any other search and seizure power.
Delete that. You must have your warrant, man, but you don't.
Okay, so in
you're relying on a warrant and you don't have it in your possession.
There is a provision in the Constabulary Force Act already, but it's in relation to arrest. But the reason it is there, you have to look at the underlying reason. The reason that it is there, even for arrest, is that you may have a time issue. At the time when you're at your JP, you may need to be executing it at the same time, simultaneously. But what it provides is that the person can still ask for the document and it must be presented to the person as soon as practicable.
It contemplates that the document exists.
Yes, so it has to exist.
But it just doesn't have, they don't have it in their possession.
They just don't have it in hand.
This is just a recipe for retroactive issuing of warrants by corrupt JPs. That's what this is.
That's correct.
Yeah.
That's correct. It fosters corruption.
Yeah. Yeah.
And abuse.
Yeah.
I think there are legitimate concerns on either side, but I think primarily is where you wouldn't want to defeat, for example, an operation if you happen to be in an area where a suspect is to be apprehended, and then you say, hold on, I can't really do anything, let me leave you right there, and in good faith hope that you're going to stand up there and wait until I go and fetch it and come back. I think that was part of it. But there are legitimate concerns as to whether it would be abused.
And that would happen.
But remember, the power to issue also, the power to act also exists where there are reasonable grounds to suspect. Without a warrant, that is.
So where there are reasonable grounds, you can in fact search and arrest even without a warrant. I'm just saying this recommendation is therefore not. What's the suggestion?
Chairman, there will be other avenues where it can be debated when we come to that stage, but my recommendation is that it would leave it.
But this is not dealing with arrest. This is dealing with search and seizure. It's one thing to book a man and you've been looking for him for a long time and you want to hold him. But when you're going to search or seize something, you should have your warrant.
Well, if you're in an area where the gang dom is,
have your warrant, man.
You don't have to have a house. You have to do what you have to do.
You know, a statement like that is a dangerous statement. Yes, but the state can't behave dangerously.
No, but you have to take action too.
And we seem not to understand that. We seem not to. We are a country governed by a constitution and not at the whim and fancy of some law officer or minister. We have to follow the constitution. Let us always remember that.
That note, Chairman, that is why the presence of reasonableness, reasonable cause to suspect, is what takes the action out of arbitrariness. And our law does not make room for arbitrariness, even if there are concerns with how it is executed. So
the provision doesn't even say where it is not reasonably practicable to produce it, or there's no language like that. It just says you can execute and produce it later, and that is just a recipe for retroactive.
Remember, I think something should be put in, added to it, a clause read along those lines. Ask member to pay attention there, right? Yeah. Now,
an attorney general could possibly
say
to the, let me finish.
Members, I hear the concerns, and I take note
Can I finish my point? If I can't, then tell me, and then I don't have to be a member.
Yeah, you're governed by the Constitution. You have a right.
I am.
Yes.
Which allows freedom of expression.
Yes.
And
well, Councillor, our colleagues are coming in.
I've taken the decision that I'm redundant in this, so I shan't say anything.
We'll adjourn. Make the required corrections suggested in this meeting and circulate for possibility of
From the last meeting.
no.
Which
Which was to be added.
practical to produce it, something to that. So it does say that, right? Yes.
Yeah, the language
All right.
suggested by.
Reasonable, it's not reasonably practical in the circumstances.
No, we take that in here.
That's already built into B because B requires the constable to show the warrant as soon as practicable after demand is made.
That's not built into B. B is dealing with a different thing. C is saying produce it as soon as possible afterwards.
No, reasonable suspicion.
The whole power to initiate it shouldn't arise unless not reasonably practical to produce it now.
Chairman, just by way of housekeeping, we would consider this the final meeting of the committee. The revised